My name's Steve Roberts. I'm Director of IRLA and Director of Claims at Riverstone. Obviously we're here today to look at joint settlement meetings. I had a couple of kind of initial questions. So, very, very high level. What's the best kind of claim? Anybody got a clue? The best kind of claim is a settled claim. I know it sounds really trite, but that's what we're here to do as claims people. We need to settle claims. So, how do you get a claim settled? Really, really, really easy question. How do you get a claim settled? Well, by agreement. Yeah, by agreement. You have to agree with the other side how to get a claim settled. What's the best way of getting agreement? JSM is one way of doing it, but I would say by negotiation, because if you end up in court, whatever you think your case is going to be decided by someone else, and you're no longer in control. So it doesn't matter what your lawyers are telling you, however good they are, whatever you think the quality of your case is, once a judge is involved, it's out of your hands. If he doesn't take kindly to your evidence, he doesn't take kindly to your story, and as an insurer, you're quite often, particularly in injury claims, quite a weak position in terms of the sympathy of the court. You're far better taking an opportunity, any opportunity really, in my view, to get in front of the claimant or in front of the claimant and his solicitor, and actually start to try and think about what it is about your case you want to put before them in order to get your claim settled by negotiation. So, one of the tools in the toolbox, joint settlement meetings. They're not compulsory, they're generally without prejudice, and you may or may not be able to achieve what you want to through the course of that particular process. But certainly every time we're at Riverstone and in predecessor businesses have gone into a JSM type process, I think almost without exception, probably without exception, we've managed to settle that claim without ending up in front of a judge. And that to me is a really valuable tool. So I think today is really quite valuable. I'm looking forward to hearing the other speakers. And I think we'll take questions as we go along. So if anything's not clear, effectively we're here for you. So someone says something you think, well, I don't quite know what that is, just put your hand up, give us your name, and ask a question, and we'll try and answer it. So without further ado, I think we're starting with Martin. Martin will introduce himself, and then away we go.
Well, I don't know whether we want to introduce ourselves at the outset for the programme as we're going to. So thanks everyone for coming on today. My name is Martin Naylor. I'm a barrister at Four-Point Court Chambers over in Temple in London. I do a range of insurance work, mainly construction and pure insurance type cases. I was called to the bar, which meant I did all my exams and stuff in 2009, and I started full-time in 2011, so that's what 4 or 5 years now of practice. And I've been involved in various JSMs and various mediations over that period of time. I don't know whether Tom wants to do stuff now.
Oh, perfectly.
Yeah, my name's Tom Finch. I worked for Riverstone for 3 years, dealing with motor claims, specifically on the outwards reinsurance. JSMs with reinsurers, invite them, making sure that they understand how we're going to settle the claim, and how we're going to go about it. More details follow on that.
And I'm Karishma Puri. I'm a solicitor at Kennedy's. I was called to the bar in 2000 and then cross-qualified as a solicitor in 2006. I specialise in product liability claims with cross-border liabilities.
Now we were debating whether we should start and walk around, but actually I'm more comfortable sitting down. So if everyone can hear me okay, I think it's probably easier to refer to documents and stuff sitting down. So if anyone has a burning objection and wants to see me I apologise. Also, I think we haven't actually said it yet, have we? How do you have the laws today, everyone? And if you don't know what that means, then you can look it up on the website. That's the story. Now the way we're going to approach today is I'm going to address for about 15 minutes on what is JSM, how does it work, and why would you do one? Obviously in 15 minutes that's not very much time to talk about the detail, so as Stephen says, if you've got any questions as we go along, then feel free to fire away. And one of the purposes, as I understand it, for YPG things is that there's no question too stupid. So if you have something you want to ask, then please do stick up your hand, because odds are someone else is probably wanting to ask it. Tom and I run through a very short sort of case study of the sort of case which might come to a JSM and the sort of concerns which, or the sort of interests which a claimant and the claimant lawyers might have, and then also the interests and the perspective from an insurer's side. Just looking at the sorts of arguments that will be made and the sorts of damages that are going to be claimed on either side. And then of course, Krishna then is going to talk about prosthetics, which comes up particularly in the little case study that we're going to talk about. Now in front of you, you've got, I think, 3 sets of slides. They're not formal slides, and you'll see we haven't done a PowerPoint presentation. They're really sort of speaking notes for us, that you can follow them through, and obviously if any questions arise and you want to make notes, then that's fine. Also at the back of them, you've got a short little 3-page collection of documents which I've put together, which you may or may not find interesting as we go through this. Now, I think it would help all of us to get some idea of what sort of layout of the room is like in terms of experience. Has anyone here been involved in a JSM before? Stick hand up. Okay, so you're not people. And of those people, was it a personal injuries JSM? No. Yes, two. Okay. And how many lawyers in the room? Okay, 4 people. Anyway, I think that's useful for us then to know what we're talking about. So I'm going to start by addressing what, how, and why would you do what is, and why would you do a JSM. And I'm also going to add to that, when would you do it, because I think that's important. So firstly, what is a joint settlement meeting? Well, it is a form of alternative dispute resolution, also known as ADR. Now this is, as its description suggests, an alternative to a court resolving the dispute between the parties. There are various different forms of ADR, and they're all along the spectrum. So you have at one end probably arbitration, which is pretty close to court proceedings. It'll be pretty formal. There'll be adversarial legal proceedings, and then there'll be a tribunal of arbitrators or an arbitrator who will decide the matter pretty much as they would in court, but it's confidential. As you go down the scale towards more sort of conciliatory and more face-to-face type resolution, you have in the middle probably mediation, which is, there's no third-party decision maker, but there's a third party that runs between the parties, basically twisting their arms to try and get a settlement that they're both happy with. And then at probably the furthest other end of the scale, you have a joint settlement meeting, where normally there's no third party, so there's no decision maker. So you're not making submissions which then someone's going to adjudicate on. You're just talking to the other side. And nor is there usually, in some cases there can be, but nor is there isn't usually a third party running between the two sides to sort of, pass points back and forth. It is one party talking to the other party. One of the reasons why, we're going to look at the various reasons why you would look at JSMs in particular, but it's very important with all court litigation to engage with some form of ADR, whether it's just a meeting at one end or whether it's something more formal, formal mediation or something. And that's now become established in case law. So the Court of Appeal has fairly recently been pretty clear that it's going to impose cost sanctions on parties who don't engage in ADR from a sort of early stage. So in other words, even if you win your case, if you've stubbornly throughout the whole process said, I'm not going to talk to the other side because my case is so good, then the court will look at reflecting that in the costs award that it makes. So you may get ultimately less of your costs back at the end of the day, even if you're successful. So it's sort of court mandated. But there are other reasons, of course, why you want to do that. I'm going to come into that in a moment. But staying with what for a minute, it is essentially a without prejudice meeting. Now, Steve's already used that phrase. For the lawyers in the room, that would be very familiar. For the non-lawyers, without prejudice is a piece of correspondence or a meeting which won't be referred to in the court proceedings. It's essentially a closed shop, sort of Chatham House rules scenario. So if you send correspondence without prejudice, you might be referring to a piece of evidence or a report which isn't necessarily helpful for your side, which you don't want used against you in court. But for the purposes of negotiation, it can be very useful to have that closed shop where everyone can sort of speak freely. You often get a tag onto that, which is the correspondence will be sent without prejudice, save as to costs. So what you're saying is, we don't want this correspondence referred to in court, but if we win, we're we talk to you about this. So for an insurer, for example, you might want to get rid of the claim for whatever reason. You might want to pay to get rid of it because you think it's a good claim, or you might want to pay it off as a nuisance claim. So you might want to make an offer in correspondence of £5,000 or something, whatever. But you don't want that to be referred to in court because it makes it look like you think there's a liability risk. You make it look like you might be going down. So you say it's without prejudice, say it's to cost, so that the judge isn't aware that the insurer thinks that it's got a vulnerability. But at the end of the day, it can, the insurer, if it wins, can then say, well, look, we tried to settle this ages ago, so we should get all our costs back, and the other side should suffer a sanction as a result. And so a JSM is essentially like that. If it's without prejudice.
A quick question which just sprung to mind without prejudice. When I send something without prejudice, is the other side obliged to treat that as without prejudice? Or?
It depends on the content. That's a good question. It depends on the content of what it is you're saying. If it's without prejudice, if the substance is aimed at settling a dispute between the parties, so you can't sort of
Sneak something in there that you don't want brought into court.
Yeah, you can't send a whole stream of questions or admissions to the other side and say this is without prejudice, just full stop. It has to be aimed at settlement. But as long as if you've got a sort of draft expert report which say admits liability in certain respects, so you want the other side to have it because you think this is going to bring you closer together when it comes to settling the dispute, you can send that without prejudice because it's aimed at settling it.
Yep.
I mean, the thing is, I guess the lawyers are going to be aware of this. The non-lawyers, if in any doubt, then talk to a lawyer before you send things to the side. I mean, it's really important actually that often correspondence between a claims handler and an underwriter, that won't be privileged from disclosure in legal proceedings. So if you as a claims handler or an underwriter are communicating, saying, well, this looks like a good claim to me, that will potentially be disclosed in the court proceedings. This isn't always an answer, but it's a good thing to copy in a lawyer to that, because then the lawyer can claim legal privilege. They can claim that it was advice related.
Just as an aside to that, and I'm sorry if I'm buzzing in slightly, anybody in the claims department who has a view on something, you've got to be very careful what you write down if you're not a qualified lawyer or counsel on that particular case. So it's always better to add little words in like it's alleged that, or it's possible that, so that you're not making an admission in those papers if they happen not to be privileged. If you happen to send them to the other side by mistake, you're not giving too much away. If you put it in a context which doesn't say, I think this, do you think that, that's what the other side can take away from that if it hasn't been privileged. So you've got to be quite careful about what you write to the claims person.
And it's funny how these internal things can come back to bite you as well. I have a case at the moment for an insurer against someone who's acting for himself, who's missing a person. And we've had to disclose all of our loss adjusters reports and all of our claims file on him. And he's a very irascible character, to say the least. He's very threatening. Every time we go to court, security gets called. And he's now gone, and I'm not joking, this absolutely happens. And he went through these sort of 3 lever arch files of disclosure, and there's numerous references to him from people within the insurer and from the loss adjuster describing him variously as a nutter, or looks absolutely nothing like Ali G, which he has previously sued someone for saying he doesn't look like Ali G. He's an Ali G impersonator. Well, he's currently got a restraining order against him, so he can't sue me as well. But that kind of thing, he then goes through and it makes him very worked up. And all that was really required was earlier in the stage for that particular loss adjuster not to have put that note on the file, or not to have sent that email to the person in the insurer.
And not these things personal. I mean, in the end of the day, you're dealing with something as professional. So be professional.
I mean, it is difficult to see.
Sometimes when people are nasty towards you or difficult, it's hard. But
so returning to the sorts of cases in which GSM is likely to be used, and you can use them in any case at all. So Simon indicated before that he's done a GSM and it wasn't in a personal injury context. You can I've done one in the context of a subsidence claim against insurers. But they're pretty typical in high-value personal injury cases, because in those sorts of cases often, again, I'm going to be teaching the insurers how to suck eggs, but there's a divide between liability and quantum. So it might be a very simple issue on liability. Who was it who caused the car accident? Pretty simple. But then the quantum might be, if it's a serious injury, then the quantum can be a very large figure. There can be lots of different heads, and there can be lots of disputes. And so at a JSM, you can have both liability and dispute, or that can be admitted, or even just not dealt with, just left to one side, and you can just be looking at quantum. And I mean, every JSM will be slightly different, but it's not at all unusual for the parties to have agreed in principle what the quantum of a case would be in terms of how many damages is the claimant going to be entitled to, what heads, how much, but then for the issue of liability to go to court to be decided, so that the judge can hear the facts and decide who was to blame for the accident, whatever it might be. So, you know, they're all different. And one of the things I think to take away from this is a JSM can be used in sort of any circumstance. They're pretty flexible because it is just a meeting. You can set one up pretty much any time. In terms of how they normally take place, well, I've described them, it's probably not a helpful description, but I've described them as pretty much like a mediation, but without the mediator. If that makes any sense. So, as you'll know, if you've done mediation, often each party will have their own little safe room, essentially, somewhere in the building. So each side will have their home base where they will meet. There'll then be a central room, normally where the parties come together if there's a mediator to talk about things in front of the mediator, and for the mediator to express his opinions. In a JSM, often that third room isn't always there, but it's often there so the parties can all come together and talk to each other, discuss discrete issues, run through the issues, and essentially swap offers in the hope that at least, you know, one or two of the issues might be disposed of, even if the whole case isn't. They're often attended by the solicitor will almost always be there, the insurer will almost always be there. Often, not always, there will be counsel, and I've certainly done mediations where I've done all sort of mediation statements beforehand, and the solicitor say, actually, no, we'll do it from here. Which is quite frustrating, and then you can wait for the live text updates as the day goes on as to how it's going. And the parties themselves may be there, they don't have to be, and often one of the sticking points to resolving a dispute can be that the parties really hate each other now, and actually having them face to face wouldn't be a terribly good thing. Obviously, you always need the client's consent to settle a case. The client has to want to settle, either to pay the money or to receive the money, but they don't have to be there. And because JSMs are so flexible, and because Stephen's already mentioned you don't have to have one, there's no obligation to have a JSM at any point in the court process, nor is there an obligation to actually settle at the JSM. But bearing in mind what I said about how the court wants you to negotiate, the court wants you to try and settle things with the side, they are highly advisable. And I don't know if I'm allowed to divert to sort of war stories, but I was involved with the subsidence JSM I talked about. We had a claimant, and there were two insurers as defendants. My insurer, and then there was a second sort of emergency insurer. And the house had collapsed, and then my insurer had declined the claim, possibly wrongly. The other emergency insurer had said, right, we'll deal with it, and instructed some firm of engineers who then allegedly made things worse. So those were the three defendants the kind of contractor brought in. And we spent the whole day arguing, basically. The claimant seemed to like us, the claimant didn't seem to think we were to blame, but hated the other two. But the other two wouldn't settle. They spent the whole day and they refused absolutely point blank to settle this thing. Because they wanted us, as the other insurer, to pay either at least a third, but ideally a half. And we got to the afternoon, and both of the other defendants just said, right, we're not getting anywhere, and they walked out. We then went to the claimant and we said, look, you know we're not really to blame here. So how about we pay you a token sum? Right? And the overall claim was like 150 grand or something. And we were like, how about we pay you 3 grand? You know, or thereabouts. And, you know, we'll be out of these proceedings, we'll be out of your hair. And of course the claimant accepted that settlement offer. So I would love to see the face of the other two lawyers, knowing that we got out of it when they left the room. But that's why I suppose if the other parties to proceedings are indulging in this or engaging in this sort of ADR, then you probably want to at least know what's going on, so you don't find the ground fall. No, probably a bad analogy, but the ground falling from under you. So moving on then to when they can be held. Like I already mentioned, they can be held pretty much any time before or during legal proceedings. But as I said in that slide there, they're usually held when they're most likely to succeed. And certainly in my experience, they're most likely to succeed when the parties are all aware of the issues, you know, what's actually in dispute between them. Is liability in dispute? Are particular heads of quantum in dispute? So that's the first issue. Are all the issues identified? And the second one is all the key evidence available, at least on a without prejudice basis, between the parties so they can actually talk about it There's no point having a mediation or a JSM until you know what the other side are going to be arguing and what they're relying on to make those arguments. So what I've done in the little bundle of documents that you've got attached, you'll see that the first page is a document which says Precedent H at the top of it. Now the lawyers in the room will recoil with fear because this is a horrible, this is a horrific exercise. It's a relatively new initiative of the courts to budget for costs at each stage of the proceedings and to kind of rubber stamp them at the start, so you have a budget which you have to work under. Now, this is one of my, I've tried redacting it, not wholly successfully, from earlier this year, and you can see the total budget that's been allowed in the right-hand column for each stage of the proceedings, which is identified to the left. So you've got from pre-action costs, which will be an exchange of pre-action letters and an exchange of reports pre-action, all the way down to the bottom, and you'll see there's trial preparation, trial, and then the ADR, settlement discussions, that has its own particular column. And if you look at the figures involved, I mean, this is a slightly warped one because this was higher than it should have been. But you can see there's quite a lot of expenditure at the early stage, pre-issue and then issue. But then after that, the biggest expenditure of costs, you'll see is normally associated with trial preparation and trial. So you see in this case, £17,000 for trial prep and then £25,000 for trial. So if you're looking at settling a case, you want to do it as early as you possibly can because you want to avoid those costs. Normally, you will also have a lot of costs associated with witness statements as well, interviewing witnesses, putting together their statements. This one isn't quite so bad. But what you have at the early stage here, with a personal injury claim, which is one that Tom and I are going to talk about in a minute, there is a certain protocol you have to follow before you issue proceedings. Again, it's not actually compulsory, but the court will hit you with costs if you don't follow it, which is where you have to write to the other side, explain what your case is, and then, if necessary, attach the sort of reports that you're going to be relying on. So, in other words, before you even issue proceedings, both sides have some idea what the claim is going to look like and how much it's going to be for. If that doesn't work, and certainly I know local authorities are not very good at actually responding to pre-action letters, you've then got to issue the proceedings, which is the second stage. Now, the issue of the proceedings, what we used to call pleadings, are now statements of case. All of the points, the legal points that each side is going to make will be set out in those. So again, the side should be able to know, I have a tree roots negligence case on at the moment. Tree roots have gone under the property and caused the property to collapse, allegedly. The council didn't respond pre-issue. When they put in their defence, we see that their defence is that the trees don't belong to them. Now, they could have told us that in the first place, right? But at least we now know, because we've got their defence, we now know that that's their defence. The next stage after that is CMC, which is case management, which is a case management conference where you go before a judge, and the judge will set out the directions up to the trial of the matter. The judge will say you've got to disclose your documents by this date, you've got to put together your witness statements by this date, and then we're going to look at having a trial in this window, let's say, the 1st to the 20th of October next year, or whenever it will be. So really it's at that stage, I think, around the CMC stage, where the issues will have been identified. You should already have, if you're a claimant in a personal injury case, then you should already have an expert report. And the defendant should at least be working on them, even if they haven't already. But that's the stage, really, before you get into the real meat of the costs in the case. That's when you should be looking at having a JSM, I think. But that said, there is absolutely nothing to stop you from having a JSM just on the eve of trial, when suddenly you think, like, let's really get rid of this, because otherwise we're going to have to pay, the solicitors on an hourly rate to sit through the trial, and we're going to have to pay counsel's brief fees to get the barristers in court to do it. So you want to avoid them. I'm very keen for you to incur them, but you as a client want to avoid them if you possibly can.
Subject to this going through the case.
Well, subject to this going through a case, but that brings me on neatly to the next issue, which is why would you do one? And why would you do a JSM if you think you have an absolutely nailed on, found with a bloody knife in your hands type claim or defence? Well, firstly, there's that issue I've already talked about, the court punishing you in costs if you don't do that. Now, you think, well, so what? We're going to win anyway. Well, the first issue is litigation risk, is that you can never tell what your witnesses are going to be like on the stand. You can never tell what your judge is going to be like on the day, what side of bed they would have got out on that morning. So I had 2 cases involving trips and slips on golf courses, and the first one we won easily. The judge, one of the first things the judge said was, "Yes, I've learned on golf. I understand all this." Second case, the judge was pretty clear right from the outset that he knew nothing about golf, and at one point we had to have our witness go to the car to get his golf shoes so we could show the judge what the studs on the bottom of the boot looked like. Like, you cannot predict what judge you're going to get on the day. The second reason why you want to do it is as a cost risk, even if you're successful. It's very unlikely, unless you've really, really tried to settle a case and you've made really good offers, it's very unlikely that you're going to get anywhere near 100% of your costs back, even if you win. There will always be a reduction. The courts almost always write you down. One of the points of this cost budget process is to stop the costs being too high, but inevitably the judge will still go through at the end, or on assessment of costs, they'll go through and write them down. So if you're only going to get, let's say, 75% of your costs back if you win, then that lost 25% makes it worth going to talk to the other side to try and settle it if you possibly can. In addition to money, it's not all about money, obviously trial can be a very stressful experience, not least for the barristers, but particularly for the people involved. There's a huge time drain for the clients, for either for the insurers or for the victim in a, let's say, a road traffic accident case, to have to give up so much time to preparing witness statements, to going to court every day. It's a drain. It's also very emotional, and it's funny how even the most noddy, road traffic accidents from the first days when I was practicing with, where the insurer is paying regardless of who wins. It's amazing how emotional people get. And if you've never been cross-examined, then I can tell you just from my bar school days, it's a horrible experience, even just in a practice scenario. And so you kind of want to save the parties that if you possibly can. And then finally, the last issue on the slide I've got there is the JSNs can be productive even in terms of reaching agreement on 1 or 2 issues. If you can dispose of half the quantum issues, well, the trial might be reduced in length by half, which is going to cut down those costs at the last stage. Now, one thing is I had a conversation with Tom, who was curious about the level of costs in cases. Now, the one I've given you here, the precedent H, you can see the total sought by the claimant solicitors is £181,939. Now, does anyone want to guess what the sum being, this is a solicitor's negligence claim, does anyone want to guess what the sum being sought by the claimant was, their best case? You just want to chuck out a number.
60 grand?
60 grand.
600.
600?
Yeah.
Says the experience litigation. Well, actually, it's somewhere between the two, but closer to 60. It was 85 on the best case. Now, they didn't get the budget of 182 grand, but it kind of goes to show that the judge did give them about 130, I think. So it does go to show that often costs will equal, if not exceed, the value of the disputes in issue. And so therefore, if you're an insurer and you think we're probably going to go down here, you don't want to be spending all these legal costs, you want to be settling it and getting rid of it. So I think, unless anyone's got any specific questions on what, how, why, or when, I'm going to move on to talk about the case study that Tom and I are going to go through. The hypothetical facts which we're dealing with are that there was a road traffic accident, something known as RTA, on 31st of March 2009. The claimant was aged 44 at the time, he's now 51. And the facts are that the claimant was riding a motorbike along the main road when the defendant pulled out in a car and hit him, knocking him off the bike. Now there's a dispute, so in other words, liability isn't admitted, the defendant doesn't admit they were to blame for the accident. But there's a dispute as to how fast the claimant was going. Was he the cause of the accident, or did he contribute to it by going faster than he should have done? The injuries which we're looking at on the next page are that unfortunately this claimant had to have both legs amputated. The left leg was amputated below the knee at the scene, right leg was amputated above the knee at hospital. There have been issues with both arms healing and various reasons surgery needed. However, the claimant himself has a positive mental attitude and is sort of trying out all the treatments available and is making good progress with those treatments. And then we see there's a couple of other injuries, interthoracic injuries and fractured digits on one hand, but again, he's made a recovery. Now, in terms of damages, we're going to see in a moment, one of the main areas of dispute and one of the biggest areas of liability for an insurer will relate to the claimant's employment, and particularly his future loss of earnings if he's no longer able to work as he would have done before the accident. So in this case, the claimant was a senior engineer or technician for Rolls-Royce. After the accident, he's returned part-time. He returned part-time in November 2009, so that's about 8 months after the accident. And he's 4 days a week from 2010 onwards. And he's recently retained his employment despite other redundancies being made around him. And there's a dispute between the parties as to whether the claimant will be able to maintain his employment until retirement, will be retired at 65 or 66. So, if those are the facts, and if you're the either solicitor or counsel instructed to act for the claimant, why would you, in those circumstances, want to have a JSM? Well, firstly, as we've already said, liability is in dispute. There's a dispute as to the speed of his bike. Now, it may be, if this went all the way to trial, it may be that the claimant is absolutely to blame and he pulled out too quickly, but it may be that the judge on the day finds that actually the claimant's going far faster than he should have been, and if he hadn't been going that fast, then the accident wouldn't have been caused. So in other words, the claimant could lose his whole claim completely. Or he may be made to pay a contribution, or may suffer a contribution negligence deduction to the damages that he gets, and that the amount of that contribution can vary from 20% up to 60%, whatever. So for all those reasons, you're going to want to go to JSM. Now, Tom and I are going to talk broadly about the perspectives that the claimant goes into the JSM with as compared to the insurer. And I mentioned this to a colleague in Chambers. So I was doing a talk on what does the claimant want from a JSM. He said, well, let's just get as much money as possible, surely. And I think that's broadly absolutely right. I mean, the court's aim, when it makes an award of damages, assuming it finds the defendant liable for the accident, the court's aim will always be to compensate the claimant, which is to put them back in the position the claimant would have been in had the accident not happened. Now, some of those costs will be quite easy to work out. If it's a cost which has been, let's say the bike was damaged in the accident, well, that's quite easy to figure out how much that's going to cost to repair or how much that's going to cost to replace. That's pretty easy to do. When you're looking at future earnings, it's much more difficult. And if you're looking at what we call a PSLA award, a pain, suffering, loss of immunity award, then obviously no amount of money is ever going to actually bring back the claimant's legs and allow him to have the quality of life which he was going to have before the accident. So the court does its best to compensate based on various sort of case law and guidance. But it's necessarily a rough and ready process. So if you're going into that as the claimant, then you're just going to push for the biggest figures that you can reasonably argue for, but having in mind you could go to trial and get much less. So looking at some of the damages you're going to claim, I'm going to move on from general damages and PSLA for a second, because all the other damages at the bottom of the first slide, namely special damages from accident, accommodation costs, and past loss of earnings. In very broad terms, there are two categories, two types of damages in legal proceedings generally. You have special damages, which are so called because they have to be specifically pleaded and specifically proved. Now they are, even if you don't know exactly what they are capable of being ascertained. So for example, the value of that bike, for example. On the other hand, you have general damages, which are not, there isn't a sort of certain value for them. They are slightly more intangible, unknowable. So if we look at special damages firstly, the kind of special damages which the claimant's going to have here, so I've already mentioned damage to motorbike, clothing. If you missed a holiday, for example, if you had medical bills, all those sort of special damages costs which are going to need to be pleaded. So the claimant's going to need to attach a schedule of loss to their particulars of claim, to the statement of case and proceedings, and then they're going to need to prove them at trial. Now that's not a very difficult thing to do. If the motorbike costs so much to repair, well then you simply stick that cost in your schedule of loss and you attach the invoice. That's the sort of thing which can be agreed very simply in correspondence before the JSM, but certainly at the JSM itself. Other costs which the claimant might have, which are also like that, is you may have accommodation costs. If you had to move into a different type of property with easier wheelchair access or a stair lift or a wet room or a downstairs property, then all those costs will be payable, will be recoverable And then we've got other past losses, but also past loss of earnings. So any loss of earnings between the date of the accident and the date of the trial, or the date of JSM as it might be. Again, you can work out those fairly easily. You may may require some cross-examination. The claimant may have missed out on a promotion, which meant he's not being paid as much as he otherwise would. But the court can identify that, and at JSM you can talk about that. So you can see what are his wage slips, how much is he earning before the accident. Is it been 2 years since the accident? Well, then that's loss of earnings for 2 years. If he's working part-time, so getting paid half as much, you compensate for the other half. There's no magic, no kind of secret to any of this really. It's just simple. It's a simple calculation exercise. So that's special damages. When you come to general damages, that's a lot more difficult. The first category, which I've already mentioned, is pain, suffering, and loss of immunity, which is the court's attempt to kind of put a figure on, I mean, obviously the pain and suffering which the claimant experienced by virtue of the accident, by virtue of the treatment since, but also loss of immunity, which can be a lot more general. So, if the claimant was a big fan of country walks, for example, well, that's a loss of quality of life, which the court will try to compensate for with a monetary award. Now, the way it does this is there are set guidelines, set starting points. So, in the bundle of papers which I gave you, then on the second page, you see a document headed orthopedic injuries. Now, this is a set of guidelines called the Judicial College Guidance. It used to be called the JFB Guidance. And it's just in very rough terms, it gives you very broad brackets for PSLA awards. So you can see about halfway down, leg injuries, amputations, loss of both legs. This is the appropriate award if both knees are lost above the knee, or one leg has been lost above the knee at high level, and the other has been lost below the knee. The level of the award will be determined by factors such as the severity of any phantom pains, associated psychological problems, success of any prosthetics, any side effects such as backache, and the risk of future degenerative changes. But you can see there there's a range. Nowadays we'd be looking at 10% uplift. Essentially a few years ago, the courts have constantly been engaged in reforms to how costs are awarded and what's sort of known as no and no fee arrangements. And one of the ways they decided to make this fair was to abolish sort of no and no fee arrangements, or one type of them, and to give a general uplift to damages award so that the claimant could pay the lawyers out of those damages. So nowadays we're looking at a 10% uplift, so we're looking at 201,000 to 235,000. So that's your starting point, and obviously then quite where you are in that bracket for the SLA will depend on those sort of factors which are listed there, but also on precedents. Now, if you have time at the end of Tom's section, I'm going to look at just a couple of those precedents to see the way they can be sort of used either in your favour or against you. But it's the sort of thing which, without getting bogged down in it at the JSM, if you were well prepared, you'd obviously go to the Judicial College guidelines for a starting point, and then you might want to have one or two authorities to kind of support going one way or the other as to the overall value. So that's PSLA. Other general damages over the page, and the key concern really for insurers is going to be future loss of earnings, which is obviously much more difficult to assess. So in this case, I set up some facts there on the second slide. Our claimant is likely to have to reduce his working hours to 3 days a week when he's 55. He's unlikely to work beyond 60. There's a risk of him losing his job at 55, and his prospects of finding alternative work are more remote, because he's now at a disadvantage on the labour market. Now, all of these things need to be compensated one way or another. Now, what the courts used to do, what they used to be required to do, was to make just one lump sum award. So, something like PSLA we've looked at, the court can kind of come to an award there and just think, well, 215,000 or something is suitable. But what it also had to do in addition to that was to look into the future. You can have a 16-year-old claimant, and it's looking up in the future, and gazing into crystal ball and looking to age 65. What do we think the effects of this accident now will be on this claimant in 60 years' time, 50 years' time? And it's always a difficult exercise. It's a hypothetical exercise, and it means that there's no kind of one right answer. But the courts have got more scientific over the years. So there are now specific guidelines, and I don't want to go into detail too much. One, because for phenomenally boring because it's so very complicated. But there are, Tom's going to, sorry, I'm trying to solve you there. Tom's going to talk about it a bit more. There are these guidelines called the Ogden tables, which will try to, sort of actuarial tables, will try and take into account the likely future earnings of a claimant of that particular age and that particular sex over until his likely retirement. But obviously there are issues of fact there. Is he going to retire at 60? Is he going to retire at 65? And those are all things which you can talk about at the JSM, and the more evidence you have one way or the other, I suppose, the better. Is life expectancy effective? The claimant says not. You might expect the claimant to say, I'm going to, my life's been cut short because of this. Well, actually, if you're looking at loss of future earnings, you're going to have more years of earnings if you live longer. So actually, in this particular case, the claimant's arguing, well, I'm going to live just as long, but during that time, my living costs are going to be much higher. And so you also take those sorts of costs into account. So if holidays in future for the claimant are going to be more expensive, because you now have to stay at different hotels, or you can't go camping anymore, for example, then that's going to be taken into account in future additional costs. You've got the future costs of carers, for example. And then additional healthcare equipment. And this comes into what Kirshman's going to be talking about later, about prosthetics. Because where you've got an amputation case like this, the claimant obviously is going to take advantage of whatever developments there are in prosthetics. And then it's an issue of, often a hotly contested issue between the parties as to the extent to which the claimant will make use of prosthetics in the future. How much will they cost? How successful will they be? How many advancements will there be? And in this case, the case study is based on a real JSM as I understand it. There was a really big conflict in the evidence between the costs of prosthetics going forward. But this whole thing's a bit like a spider's web. So if you put on one strand, it'll affect somewhere else. So if the claimant's going to be spending more on fancy prosthetics, well, then arguably his quality of life is going to be slightly better as a result. So arguably that has an effect on the PSLA award, those sorts of things. So they're all things worth keeping in mind at JSM. So coming on to prosthetics in the final slide there. Currently the claimant uses prosthetics to rest his limbs in the evening. He has full use of prosthetics subject to wear and tear, lacks protective sensation and stumps. In other words, if he continues to use prosthetics, he's going to suffer wear and tear to his body more than he would otherwise. So again, that links back to the expert issue. How much use of prosthetics is he likely to make in the future? And then he may need further surgery in the future. And so with all these sorts of cases, the key issue will depend on what the experts think. And I mean, all these sorts of high value cases with those sorts of conflicted issues, you're going to have experts involved. You're going to need to get an expert report as early as you can, and hopefully a good expert. And it's not uncommon, I think in my experience anyway, for experts to attend the JSM. Experts normally are quite good at approaching things in a slightly more detached fashion, and can engage with the expert on the other side. So again, even if you don't settle, you might reach a degree of consensus over issues such as prosthetic developments. Now there are lots of other factors you take into account when arranging a settlement, and one of them, I'll just mention this briefly because it's become a particular bugbear of mine, which is tax, which is very boring. But if the claimant is getting a lump sum award now, representing future earnings for years to come, well, arguably he's not going to pay income tax on that sum, which he would pay in the future. You don't get tax generally on personal injuries damages. So in other words, the defendant's going to want to reduce that award. It's called a Gowley award, reduce that award to reflect the sort of the tax contributions, tax payments he would have to make. And similar goes for pension contributions. If you're compensating the claimant for loss of his pension entitlements because he didn't work so long, well, you've also got to reduce to take account of pension contributions that he would have had to make. So like I say, it's a very complicated spider's web, and I mean, obviously in every case is different because it's so factually, so fact specific. But hopefully these sort of red lights which should come on now, things like tax and the general process, and unless there are any specific questions on the claimant's perspective, things the claimant's interested in, then I'll let Tom go native and talk about insurance side.
Thank you. Got my bias that one. Right. So, an insurance perspective, why would we want to use a JSM? Well, Stephen and Martin touched on it slightly. A JSM can be used to settle a claim earlier and therefore reduce the amount of insured after paying costs. Obviously, we've looked at how expensive a lawyer's solicitor fees can be. Secondly, a JSM can be arranged at any time during the JSM. It's obviously useful, there's no pressure on when to use it at all. You either start right before trial, as Martin mentioned. As the claimant is often present, it's another positive. Obviously, you can have better negotiations with the claimant, a personal one-to-one, or with the solicitors there. Obviously, it's better to and easier to negotiate than just going through a solicitor sometimes, and you can easily settle.
Can I make one observation there though? From an insurer's perspective, if you go in absolutely adamant that you want the claimant to accept part responsibility for the claim, you may leave before you get to the end of your sentence. So you really do need to work out what you want out of a JSM before you get there. So if it's a purely financial sum you're trying to beat, try not to get too bent out of shape about how you're going to get there, because sometimes the claimant might want to start with an apology and he might want to not be responsible, and if you can deal with the claim from his perspective, actually look at his requirements or her requirements carefully, you can get into quite a good position as insurer, independent from your insured, and have a more grown-up debate about what the claimant actually wants outside of the emotion of the claim. So we did have a JSM not so very long ago, as I say, where we turned up and the claimant left within 5 minutes, and you're not going to do anything on that basis. So know what you want.
Yeah, and then as mentioned before again, without prejudice forum. So any offers and omissions made during the meeting can't be taken to court, and it's called without prejudice. And as Stephen, you've said, I was just about to say, the JSM is only useful if both parties are willing to negotiate and discuss. Obviously a more formal meeting would be arranged if we're not willing to negotiate, and that's both sides. Obviously insurers will have to be open to negotiations as well. So, moving on. Here I've just listed a lot of different types of damages and costs, which be associated with a bodily injury claim. You've got general damages, special damages, and legal costs. So obviously Martin's gone through a few of them. Your general damages tend to be your intangible past losses, so the ones that are more difficult to quantify, such as your PSLA, and your future costs, so your future loss of earnings, your future medical costs, care and case management. Special damages, so they are your quantifiable past losses. They're the ones that can be easier to calculate, so damage to property like your motorbike, for example, or past loss of earnings, past medical costs, such as that. And then legal costs, so your own solicitor fees, and then the fairly big one, claim solicitor fees, can potentially be quite big. So what the insurer to negotiate in such a claim? Well, again mentioned earlier, advancements in technology. It's quite disputable how much prosthetics are going to be in the future. Obviously, they could get quite high. In this case, the guy with double amputation, so obviously he's going to need prosthetics. But in this case, an insurer will find it very difficult to argue against not giving the claimant the very latest technology. I think the court's quite in favour of awarding the latest technology, especially if it's going to benefit the claimant lifestyle. Loss of past earnings, so a claimant is normally going to be for lost earnings. It's got double amputation. He did continue to work, so any earnings that he would have made would be obviously taken off the cost of the claim, but normally that isn't really disputed in this case. It is often disputed though when a claimant is able to go back to work. to, and therefore that obviously there's quite a bit of discussion there and needed, and maybe not even resolved in the JSM. Contributory negligence. So again, there was debate about whether the guy was speeding on his motorbike prior to the collision. I think we'd be lucky to have the claim completely 100% contributory negligence, but there will be an element of that. Definitely try to negotiate it by the insurer as to saying, well, hang on a sec, you were speeding over this limit. We want a discount of 20%, let's say 30%. And moving on again, life expectancy. Life expectancy is always tends to come up in the bodily injury claim. In this instance, it didn't actually affect his life expectancy, but therefore, as would you say, the spider web effect almost. So because the life expectancy hasn't been affected, the PSLA would go down, well, slightly, you'd hope, and therefore reduce the overall claim cost of the claim.
Just going to that point about people who manage to get back into work from an insurer's perspective, one of the advantages of getting a JSN early in those circumstances is that whilst that person is working, that can be taken into account. If you drag your heels when you know you've got a liability, hoping for some miracle in the evidence, it might well be that person isn't going to work anymore. And some of the advantages that you may have gained from their good offices, their attempt to get back to work, them being at work, would be lost to you. We've seen many claims where 3 or 4 years after an accident someone is working, 5 or 6 years afterwards, if you failed to get to an agreement with them, they may have fallen out of employment. The cost for all of those future years of employment goes through the roof. So you've got to be very careful what you're trying to do as an insurer sometimes. You're trying to be really tight on liability. You might, if the other side won't come to an agreement with you, find yourself in a worse position when you finally come to settle that claim because of other circumstances.
Following on just from what you're saying there,
Yeah.
say a settlement is reached at an early stage where obviously taking into account all the circumstances at that point.
Mm-hmm.
Once that settlement is made in full and final, is there any way that a claimant could then approach again, say 20 years later, because his life has significantly changed, obviously circumstances that the insurer and the defendant wasn't aware of at the time?
Not in the UK if the agreement has been signed through a solicitor and if that claimant happened to have a mental incapacity and therefore needed to be signed off by the courts. The courts have signed it off full and final. In the UK, that is full and final. If there are some aspects of that person's disability at the time that you're making the award which need to be taken into account by the courts or by the settlement that you agree, in the UK, only the elements that you agree at that time in relation to future disadvantage need to be taken into account at some later stage if they happen. Whereas in the European courts, interestingly, or in the European jurisdiction, in the main, whatever you've agreed, the person always has the right to come back if there is a deterioration in the medical condition. So what we see on our book is a difference between our UK settlements, which generally are higher up front, interestingly, but are final in, I would say probably 98 out of 100 claims, they're final, of these serious types of claims. In the European cases, they tend to run for much longer with a lot more medical change coming in as the claimants age. So if there's a requirement for more care in France or in Germany or in Italy or in Poland, four that I know, that person can come back to the courts and ask for that to be taken into account many years later. So different circumstances.
Not good for finality.
No, so in the UK we're lucky in the sense that broadly we do get finality, so settling claims from a UK perspective is definitely the right thing to do.
Can I just add also, outside the UK, so for example in Italy you'd be entitled to things like moral damages as well. So you might have someone who gets burned due to an accident, and then it won't just be the claimant's PSLA, it will be the claimant's cousin, sister,
Yeah,
mother,
and in
father,
Scotland.
grandmother, and again in Scotland. Yeah, and then you can see how the claim was put.
Although interestingly, in the Italian system, we have some medical malpractice claims which have the same kind of medical outcomes, if you will, as some of these motor and other injury type claims. jurisdictions sometimes follow the national characteristic. So in countries with that very strong family base, you tend to find familial damages going through the system. But great question. Sorry, Tom.
That's fine. So carry on with our negotiations. So a lot of future earnings and future care and case management. That's normally quite a high cost when it comes to bodily injury claim. The guy obviously had a double amputation, and there's obviously going to be an obvious future loss of earnings there. And the likely award for such things would be something called a Smith Manchester Award. This is basically where a claimant has suffered an injury and he's become disabled and is disadvantaged on the open labour market and therefore is less likely to be employed in the future. And then, because future losses are so difficult to calculate, such as the future earnings and the case and care management, we use something called Ogden tables, which again Martin mentioned. These are statistical tables which actuarials use to calculate a future value on a lump sum basis. So it's very difficult to work out how much someone's going to future earnings are going to be in sort of 30, 40 years of a career, especially if they're sort of 20 years old. And so what these Ogden statistics do is look at life expectancy, gender, retirement age, for example, and basically allow a more accurate figure to be made, and therefore the claimant isn't overcompensated if a lump sum is settled at. So finally, I mentioned this just now. There's two methods mainly of how a bodily injury or a claim can be settled. So we've got a lump sum and a PPO, which is a periodical payment order. We'll look at lump sum first. So a lump sum is exactly what it says. I've mentioned it. For future losses, the Ogden tables would be used to calculate for earnings. They'll look at the retirement age, for life expectancy. Sorry, for care and future care costs. They'll look at life expectancy, and they'll give a statistical multiplier which will apply to the value of the claim, and so a lump sum value, an accurate value can be made. Obviously these are estimates, but they are the best estimates. Secondly, when looking at past losses, looking at a lump sum basis, when calculating your reserves, you're obviously going to have to do it on the anticipated time of settlement and not when the costs were incurred, because then you're going to under-reserve, and obviously under-reserving is never a good thing for insurers. And then PPO. So a PPO, it can be, well, in terms of the philosophy of the company, different companies will have a different philosophy of whether they want to use them or not, or try to negotiate with a PPO. They can be positive. I mean, both PPOs and lump sums can be favourable from both a claimant's point of view and an insurer's point of view. So, for example, a PPO would be favourable if, let's say, the life expectancy was disputable. In this case, it isn't. But if it was, and they agreed on a PPO basis, and the claimant was to pass away earlier than expected, then therefore the insurer wouldn't have to pay for the X amount of years. Well, I should explain, sorry, the PPO. So a PPO, a periodical payment order, is where instead of paying a lump sum, the insurer would have to pay X value for Y amount of years, and that's obviously agreed in the JSM or wherever, and yeah, so that would have to be calculated separately, and I've lost my way. PPOs, yeah, so you've got PPO or lump sum, both can be favourable, and just depending on the circumstance. In this instance, the life expectancy isn't affected, and therefore you wouldn't look to do a settle on a PPO. However, claimant lawyers and claimants will want finality, and therefore will tend to look for a lump sum. That means they'll get the payment up front, and gives finality to insurers as well. So it can be a win-win either way.
I'd add a little bit in there, if I may, Tom.
Yeah.
The PPO has come into usage because the courts think of it as being a more accurate way of measuring damages for an injured person. So what the courts is trying to do is put the injured person as close to the position they would have been in before the accident, had the accident not happened. With a PPO, as long as it's been correctly calculated, for the rest of that person's natural life, they will receive an amount of money commensurate with the amount of care or loss that they've suffered at that point in time. So if you had someone, a child plaintiff would be a good example, I think, who's severely injured in a car crash, they may well out-survive their parents, they may well live a long time into the future. Paying a lump sum now for that claim may never get close to covering all of the costs of that damaged life all the way out into the future. So it would be quite likely that the courts would prefer a PPO to give certainty to that injured child who can't take care of itself, it's not got mental capacity. So the courts might favour a PPO in that circumstance. More mature claimants, perhaps who haven't got head injury, so it's a bodily injury, may well want to take control of their life and move away from the claim, the circumstances of the claim that they have in front of them, and may think more favourably towards a lump sum settlement. So it's final for them. We generally as insurers prefer a lump sum because it's final for us as well, and you can work out all the boring things about how much you retain as an insurer and how much goes out to your reinsurers, and everybody has certainty. But where you've got very severely disabled people, the courts favour the fact that they'll be covered forever, and depending on how long someone lives after an accident, that can become very expensive for an insurer, and in fact we'll give a couple of examples later on how that works, but that's kind of the difference between the two.
And finally, I've just put down at the bottom, keep reinsurers updated. So on a third party bodily injury claim in motor, there's not a limit of how much the claim can be, so it can be very expensive, and generally insurers would be reinsured on an excess of loss basis. Therefore, when you come to the JSM, you should keep your reinsurers up to date, explain how you think the method of settlement is going to be, and basically give them notice of what you think the value of the claim is going to be and how you're going to settle. And that is from the insurer's perspective. Moving on to
Can I just ask, sorry, for the PPO, so are you paying a different value each year? Because obviously, so say with a child, they don't have a loss of earnings at that point, but they already know to earn life. Does that then move with their life, or is that a set amount?
Each case is specific to the case being settled.
Okay.
We've got some which are very straightforward. There's a fixed amount, and it's the same amount every year, generally just adjusted for inflation, which would probably use an index called ASHE, which is based on cost of care inflation over time. It's quite an expensive index actually. It's generally running ahead of general inflation. So 30,000 this year might be 32,000 next year, and 35 the year after, and so on and so forth. Rubbish maths, forget maths. We've also had circumstances dealing with the point that you raised, where there's a realisation that there's a difference coming in the future of that person's life at given points. So if someone's having an accident at 50, between 50 and 70, they might be perfectly capable of continuing to work, they may have a reasonable quality of life, but there's an expectation that at 70, take this amputation case in point, their legs might wear out in such a fashion that their prosthetics are no longer suitable, and therefore they're moving from being ambulatory on prosthetics into a wheelchair at that point. And the PPO might change at that point to take account of that difference at that point in time, and then again at a further point. So all of that can be worked out mathematically, but it will be quite specific for the individual.
So is that worked out when that's begun, or does
When
that, or is
at the point of settlement.
there's also examples where you can have a PPO for ranges of years, can't you?
Yes.
Well,
Yeah.
so you know,
Yeah.
I think there's one that I've looked at as well where you've got 3 different values for 3 different years. So when they get to 60 to 70, and then 70 to 75, and then 75 and onwards, and there'll be different.
Assuming they get there.
Yeah,
They may not get there,
yeah.
yes.
But they have different
Mark, can you
values
also
for different
Well,
ages, basically.
What I was going to say is when we're looking at we're talking about lump sums and PPOs, we're actually talking about orders that the court can make. And I think there's a distinction between that and what the parties can actually agree. sums. They only had the power to award lump sum. So it did the best it could with the kind of crystal ball exercise. In, I think it was the mid-90s, maybe about 96, there was a statute passed which allowed courts to make periodic payment orders. So it's a specific order of the court. So instead of saying, we're going to give this claimant £24,000 a year and we're going to use the option tables to work out that times by the life expectancy, instead we're going to award £2,000 a month, you know, for the rest of this claimant's life, and that will be adjusted according to whatever index you're using. But and so obviously when you're talking about JSM, you're going to start with those kind of options. And what the court could do, even with lump sums, is it could look at different periods. So if you're saying that if there's expected to be a change at a particular time of life, then the court could even on a lump sum basis use a multiplier for one period of time, and then use a different multiplicand and a different multiplier for the next period, and kind of package that all together to get the overall lump sum. And they can do that with PPOs as well. So that's the sort of court's side of it. But also you can completely separately in negotiations, what the court can't by itself make any sort of structured assessment of the parties. But what it can do is it can approve an order which the parties have reached. So if you in a GSM, if you reach some kind of novel, sort of crazy kind of contingent arrangement basis, you stick it in a settlement agreement, the court can approve it, rubber stamp it, and then it's just a matter of enforcing that agreement in the future. So again, that's kind of an advantage, I guess, of GSMs. It allows you to be a bit more creative than the court can be, because the court is constrained by its jurisdiction.
Although us crazy insurers generally don't want to get too funky, we want to get a lump sum if we possibly can, because it gives us certainty and every insurer certainty. So very occasionally we might approach a JSM holding out the possibility of offering a PPO, but we might be doing that because we expect that the other side don't want one. So we're being a bit gamey in the way that we're approaching a JSM in those circumstances. But in the end of the day, all of these mechanisms, particularly if you have a full liability, are to satisfy the claimant with his representative at the right value for the claimants in front of him. Certainly once upon a time I think insurers used to lowball these kind of games. They used to go in with silly offers and they think that would make a difference. Frankly, in current parlance, you do that, the JSM fails and you just wasted your money. You've got to go to any of these types of arrangements, subject only to considerations around contributory negligence in injury claims, where there might be some margin for discussion, with a sensible value in mind, which is likely to at least entice the claimant towards settlement. If you go in way low, they'll just say, thank you very much, no thank you. Occasionally, they have lower expectations than you expect, and you can work on that, but that's because they have needs or knowledge that you don't have in your armoury of investigation. So if someone starts with numbers, usually quite easy to try and get someone to give you a number to start with rather than you give them a number, because you can see where they are in their deliberations. But sometimes you get an inkling of a JSM and someone doesn't want what you think they're due, and then from an insurer's perspective it's a question of seeing how you can negotiate to a point that's satisfying for both parties.
Claimants lawyers often you try to work out as far as you can what's the insurer's reserve.
Yep.
Because as long as you're
so they want secrets that you've got.
As long as you're coming in around about the reserve.
And you want to know what they've got in mind, and round numbers sometimes are the answer there. But anyway, we're getting a bit detailed, and I think we should get into our final section, otherwise we'll be hitting.
Okay.
Thank you, good question, great question.
I'm just going to look at what actually drives claim costs up. There's going to be some overlap with the Tom and Martin's presentation. So the main reason, I mean, I could have kept this really short, but the main reason that costs go up is because as the technology improves, it becomes more expensive. And as Martin and Stephen mentioned, ultimately the claimant's entitled to be put in the same or as close as the same as possible position as if the claimant had not been injured. The claimant's therefore generally entitled to the best technology available, although ultimately it will be down to reasonableness, and that will be decided by the court. So the main point here is the better the technology, the more expensive it's likely to be, and that's going to drive things upwards. Just going to have a very onto integration. This is already used in dental implants, hip and knee replacements, and it involves surgically implanting a prosthetic limb directly into the claimant's bone. It takes away the need for a socket-stump interface and generally leads to improved function of the limb.
Can I say that
Yeah.
would probably increase pain and suffering?
Yeah,
So the
trauma,
PSLA
that's right.
award will go up because you're drilling directly into someone's leg. And you can imagine that can be quite painful. So because you caused the original accident, there are still consequences to that original accident happening as you're trying to put them back into the position of that person. So hopefully we've paid the answer to explain that to you. So there are, again, that spider's web idea.
Absolutely. And then we've got something called muscle re-innervation. I hope I'm saying that properly. This is quite complicated, but I'll try and talk us through it. So you have a patient with an amputated limb, and the nerves in the amputated limb are surgically redirected to a muscle somewhere else in the patient. And then when the patient tries to move their amputated limb, the signal in the healthy muscle is received and contracts, and then helps the amputated limb to move. So basically the healthy muscle helps to operate the prosthetic limb. Then we have myoelectric limbs, which is operated by the user, and this time the user is relying on the residual muscle, so where the prosthetic limb would be attached, and then through electronic sensors you're able to try and move the limb. And then the final one, which is my favourite, is the ecoskeleton, which I spelled wrong. And this is an amazing, in fact we'll see a picture in a minute, but it basically allows some people who are paralysed to actually have the ability to walk. It's run on a battery, and this battery pack can last for about 8 hours, and I'll show you a picture from that. So here's just a few pictures and case studies really briefly. We've got a 29-year-old guy who was involved in an accident. He was really sporty before the accident, and he's continuing to pursue his love of sport. He's been fitted here with, you can see the prosthetic limb. It's got a rechargeable battery with knee sensors and ankle sensors. And I read about this case in detail, and this guy's living a really active, happy life with that limb. But again, it says here that the battery power itself lasts for a period of 5 days, and then he has to recharge it. So, moving on, we've got a young boy who sadly lost his arm, but is delighted with what he calls his super cool arm, his bionic arm. And this allows him to carry out activities, he can drink, he can eat, he can get himself dressed. The only issue is that this limb is not waterproof. So when it comes to bathing or swimming, he'll have to remove the limb and manage without it. And then over we've got the ecoskeleton. And this guy actually in the picture had a BMX accident, and he was left paralysed from the waist down. But within half an hour of being fitted with an ecoskeleton, he was able to stand and walk. I think these ecoskeletons have smart apps, so they can actually, the hospital can track the patient's progress, see how much they're actually walking per day using the apparatus. It's mostly used for spinal cord injuries, and this particular one that we can see in the picture costs around £30,000. But as we've spoken about it, it might last for a couple of years and then you need to replace it. And as your body ages, so will the ecoskeleton will have to be adapted. So that's where the costs go up. Okay, so again, what actually drives claim costs up? Well, the main issue is that they are extremely expensive. In Camping Chem, I read that reported cases for the actual provision of prosthetic limbs is in a bracket of around £200,000 to £500,000. And again, I think that's because it anticipates the prosthetic limbs being replaced over and over again. And they often allow for a spare limb as well. So you've got one limb fitted, and then you've got one limb which you can keep at home in case something happens. So you almost have like a double provision throughout your life, and that's where the cost goes up. Here are a few case example averages. So for a prosthetic limb below the knee, you're looking around 73,000, and for a prosthetic limb above the elbow, it would be around 55,000. And if you use the digits on your hand, you're looking around 40,000 rehabilitation, the actual crazy expense of the prosthetics themselves. As Martin mentioned, adapting your home, having special equipment, and things for travelling, transport. So these all again help to make claims costs really expensive. And then I've got just a very quick glance at a case which I found on Lawtel. This involved a 10-year-old child, at the time, he was 10 at the time of the accident, and his leg was struck by a propeller on a rescue boat in 2006, and his leg got amputated above the knee. And here we have the lifetime provision of a auto-back junior-powered prosthetic limb, plus the spare. And the entire case settled for 2.3 million, and there wasn't actually a breakdown provided, but Lawtel kind of brought out some of the breakdown. And the biggest one was 615,000 for future prosthetic costs. So you can see the big ones I've highlighted: future care costs, future accommodation costs, and then the whopping 2.3 million as an accident.
In a sense, though, I'm sort of slightly encouraged by that because
of the age of the
well, because of the age, and because the things like future loss of earnings are actually over a lifetime relatively modest, which suggests to me that the advantages of the improvements in things like prosthetics can be quite effective in controlling the other elements of claim.
Yeah, and I'm going to come on to that.
I'm sorry.
But that's good.
I'll shut up.
No. Okay, yeah. So Stephen's ahead of me. So so what could actually move, drive claims costs down? And Martin also touched upon this. So what I've said here is that arguably the more technology improves, the more the prosthetic limbs can hopefully match the biological limb function. And then in turn, the claimant is going to be more independent, they're going to be less dependent, and this is going to substantially reduce their future requirements. It's going to reduce their potential future loss of earnings claims. Just generally, you're hopefully going to see the cost coming down because you're going to be able to argue in court or at JSM, look, the limb's amazing, required is not restricted, they're going to have a kind of a nearly normal life relying on that prosthetic limb or multiple prosthetic limbs.
There is quite an interesting non-insurance case of a climber who lost his lower leg in a climbing accident. No other parties involved, and he's now developed a prosthetic lower limb, which he claims is actually better than his original leg. So things are moving on tremendously quickly. He's got more power, he's got more grip.
I was thinking of Iron Man as well. I mean, with an Iron Man suit.
Yeah. They can
I'd
run
like to
like
see the insurer run that argument in court.
No, but it's just
You're better
really
off.
interesting. And that's I'll give it a go.
So,
I need to be embarrassed.
and then I've just put that obviously it remains to be seen if this potential reduction will actually outweigh the increased cost of prosthetics. So it's kind of that balancing act. And then we're going to have to see that on a case-by-case basis. So it's kind of a watch and learn. This is, I just thought it'd be interesting to see from the perspective of bringing claims costs down as well. The fact that we have to take into the history of the claimant when we're looking at the costs of the actual prosthetic limb. So I'm not trying to be kind of silly about this, but let's say you have a devout Muslim who has a full burqa and doesn't show her legs, but then has a prosthetic limb and starts claiming for cosmetic coverings of her leg, so she wants the leg to look pretty when it's on display. You could technically argue, well, you're not going to be revealing your leg, you never have, so we're not going to accept that part of the claim. So it's kind of just being creative. I think this would be more a special damage because it would be actual. So you can actually buy coverings.
Yeah, okay.
So you can have like a high heel attached to your prosthetic limb if you want to be a bit more glamorous.
Oh, really? Okay.
But if you're not someone that's going to plonk around in high heels, then maybe I'll tell you actually don't be silly.
You make a very good point actually there, which should be borne in mind. UK is an adversarial system, so the point was made earlier that the claimant will make the largest reasonable claim that can be made. That largest reasonable claim that can be made, because it's the top value of every line, will be an overstatement of claim. And similarly, the defendant side will probably come in with a number which is at the lowest end of that particular range. And somewhere in between is probably something approaching the right number. And so sometimes when we talk about these things, I mean, that's a good example. I hear that example, I think, oh, that sounds a bit harsh. But in fact, when you're faced time after time after time with claims at the top end of ranges, and you have a balance sheet to protect, you're looking for the right value of that claim. And the British system says one side goes high, other side goes low, and you meet in the middle. So there is work always to be done on these claims to find the right number, and we shouldn't be afraid of actually stating that what we're trying to do is find the right value.
And I've got another example of somebody who's got, as part of their claim, they want to have special sports equipment, adapted limbs. But when you look at the history of the claimant, they never played sports, they weren't interested in anything at all. So, however, again, because it's case by case, my own cousin had a really unfortunate accident, and he's now tetraplegic. And pre-accident, he was kind of active, but not that active. But the moment he became tetraplegic, he started doing bungee jumping and skydiving. And he just, like, he's all about the thrill now.
Why not?
So again, it's kind of what's reasonable, and like understanding that the claimant may well want to change how they were before. And then another, this is my favourite one, the emergence of 3D printed bionic limbs. And this is a lovely example for insurers where a hand, so can cost £1,000 per unit compared to an average cost of a bionic hand which ranges around 30,000. So 3D printing is really hot right now, and I'm sure you've seen it in the headlines in the news. There are so many things that are being printed off, and limbs are, you know, hip replacements and hip implants and all sorts. And slightly futuristic and crystal ball gazing, but I've also read that they're even anticipating 3D printed human tissue. So you may even have a heart 3D printed in the future by just inputting human tissue themselves into a
We
machine.
can give one to each insurer.
There we go. So these are kind of,
Can you imagine how the doctors in the cost?
well, there we go. Okay, so just to conclude, for at least the foreseeable future, as technology advances, so will the costs of amputation claims. But equally, the improvement in functionality of these prosthetics will allow claimants to hopefully lead more independent lives and hopefully thereby reduce their claims. The main battleground is going to be proving the need for the expensive technologically advanced prosthetics, and as always, the crux will be usefulness to the management of such costs.
There we go. So, I think that concludes the main part 4. I've been asked just to quickly wrap up the for the youngsters amongst us socialise. That won't include me, I don't think. The case that we were talking about broadly throughout that discussion was based on real events. The individual concerned was actually a pretty impressive person. Bear in mind, he lost the majority of 2 legs. He actually managed to hang on to his job on a 4-day-week basis rather than a 5-day-week basis through several rounds of redundancies at his business. He was a highly skilled computer technician for a global business, and that actually was extremely helpful in getting the claim settled, because had he lost that job and he was very highly paid, this claim would have settled for an exceedingly greater amount than it actually did. So you always take the claimant as you find them. If he'd have had a head injury in that accident, this claim probably could have cost somewhere in the region of 10 to 12 million pounds. It was actually settled, allowing for the life expectancy on a small PPO element of this claim for around 2.3 million of damages. That was made up of 1.5 million of lump sum, including interims that was paid earlier on in the case to make sure that he had everything that he required while we were getting to the final settlement of the claim. And that's something else that's quite important. Sometimes, if you're not careful as an insurer, you sit behind your wall of defences, you don't make a relationship with the other side, and of course when you come to try and settle, they don't like you very much. So in this instance, we had been prepared to pay interims right the way through the process up to the JSM. We did actually get a small deduction for contributory negligence. I don't think we would have got that in court. We did get it in the JSM to get the claim settled, and we got 10% deduction for the speed that he was travelling. We didn't have evidence to establish the speed that he was travelling, so it was circumstantial. Our driver actually wasn't speeding, but he was at fault. So effectively, we weren't going to win that argument in court. We conceded very early on that was likely to be the case, other than the small contribution we received for his speed. So he probably knew he was going faster than we knew he was going, but we couldn't prove it, and that helped get the claim settled. Bearing in mind the amount that claim is going to cost, about 840,000, that is future loss, by the way. The periodical payment's about £38,000 per annum for the rest of his natural life. The interesting value in that particular claim, I thought, really was the solicitor's costs. Anybody want to have a guess at the costs for the solicitors on the claim settling at 2.3 million?
The claimant's cost.
Claimant's cost, yeah.
Is there a CFO?
No CFO. No, much better than that, but it's still a lot of money. It wasn't 1.5, it was less than 1.5 million.
70.
Still slightly less. 600,000, yeah. £600,000 someone earned for a claim that we were liable for anyway. So again, going back to our costs were till 300,000. So general rule of thumb, the defence costs were about half the claimant's costs. Obviously, we could have run on to court for a 10% contribution, which we probably wouldn't have got. The value of the 10% contribution would have been swallowed up in the costs, and there were other elements of that claim that could have run out of control. So it was definitely one that we wanted to settle, and we were pleased to do so. He just wanted to get on with his life. He came to the mediation, and he just wanted to be done. So it worked out very well for everybody.
You mentioned earlier about the value of an apology or sending flowers. It's absolutely incredible how, even with commercial clients, so often they don't really care. Well, they obviously want the money, but really what they want is just an apology. They want to say, "I'm really sorry we mucked up.
Yeah, we got it
sorry
wrong.
about this."
That's easy in the JSM when you actually get to see and meet the claimant rather than for his solicitor.
Yeah, it's all a bit hollow, it's all at arm's length, but if you can find a way to say that. I mean, it can be difficult, of course, because you've got your own client to consider as well. If your own client doesn't think he's liable, it's very difficult to say something other than generically sorry. But the court's quite clear, you can apologise that it's not an admission of liability. You can just say, I'm really sorry that this has happened. That's allowed, and you should, because this man's been badly injured. So, know what you want as an insurer. Think about how you're prepared to settle, how far certain aspects of the claim are important to you. Make sure you're carrying your own client, otherwise you might not be able to settle even if you've got a banner in front of you. And try as hard as you can not to make cost the cause. Really easy to argue about everything because you're empowered to do so, but that can be the wrong outcome on a vast number of claims in a lot of different circumstances. So, try and get to a position where you are able to settle. Arne's absolutely right, of course. You actually need to know what you're arguing about before you try and settle. So if everything's uncertain, that's not the time to be starting to push for settlement, because you simply won't be able to catch hold of all of the moving parts. By the time you get to a JSM, you might only have 6 months or so to go to trial, but it's still worth getting in there and getting that done before the trial costs run. If you can get it done earlier because you have certainty from the medical evidence, get in as early as you can. Doesn't mean to say the other side want to, but eventually when you get in front of a cost master, if you can get out all the papers where you can show all the times you tried and they didn't want to, you will actually get some sympathy for that. So, best claims are settled claim.
Moving to opportunity for other questions.
Yeah, of course. Please.
Got a question.
Tom.
Martin.
Tom.
For future losses, have you ever seen where they've looked at genetics? So if someone comes from a family who's got two parents from Oxford scientists, and they're trying to calculate his potential future.
Sure. I can't say I've had a case myself, but it would definitely come into it. I think if we didn't have time to get there, but there are some cases both his legs were amputated, and the fourth sentence in the report says his parents, both university graduates, have been very keen in outdoor pursuits and have developed a similar keenness in him. I think the suggestion there is that one, he's going to be really into outdoor pursuits, and he's probably going to go on to do, to be quite a high flyer. That's the suggestion. So it goes into the kind of
They do look
PSLA and then the likely earnings.
Depends if it's relevant. I think the biggest claim that I'm aware of in the UK is exactly on the basis you described, Tom, where an infant claimant received a head injury, which was likely to be highly debilitating for the whole of the rest of that poor child's life. Both parents were partners at one of the top accountancy firms. And I think that claim was settled for in the region of 25 to 30 million pounds by negotiation. So you can imagine if you hadn't managed to negotiate it, where that may have gone. So, I mean, the expectation for that child before the head injury, and this is without knowing how that child would have developed at all, is that the circumstances were such that it was likely to become a partner in the top firm, be it legal or otherwise. So, that it's very difficult when these things happen.
I mean, it's an insane hypothetical exercise,
Of
which
course
the courts
it is.
have to conduct
It's
in terms of
impossible.
into the future to try and figure out what the likely values are, but they have to do it. And for PPO, they had no alternative. So they just have to work with the best evidence and the best sort of estimates they can get.
Can I just say as well, Martin touched upon this when you were talking about tax implications and all sorts, but we talked a lot about the loss of future earnings, but there's also always that dreaded pension that's kind of added on too. And I'm trying to defend a claim at the moment where liabilities is admitted, but we're just kind of figuring out what we're absolutely killing each other on quantum. And the lady had an adjustment disorder for a period of 12 months, and she claims that's the reason she left work. But she's now recovered from the adjustment disorder, so as far as we're concerned, she can go back to work. And there we go. But she's got a £200,000 claim just for loss of pension, because she's claiming that she'll never benefit from the same pension that she was entitled to where she was. And the claim is just getting bigger and bigger.